Hello, I'm Jaspreet on this side. I'm company secretary by profession, and this is our 15th or 16th. Let me check. This is our 16th video on revision of Companies Act 2013. We are using Saransh by Institute of Chartered Accountants of India because I find it graphically very appealing. And disclaimer alert that this is only for revision purpose. So in our last video, we had covered terms of auditor, disqualification of auditor, removal of auditor, resignation of auditor, and punishments for any contravention relating to provisions of auditors appointment related provisions. So now we are proceeding with appointment and qualifications of directors. So now board of directors. Board of directors. Okay. So board of directors, we have board directors. Board is collective body of directors of the company. So section 10 subsection 10 section 2 subsection 10, collective body of directors of the company is known as board. And directors, a director appointed by the board of a company under section 2 subsection 34. So a director appointed to the board of a company, that is a director. Provisions related to appointment of directors in the company. So first is number of directors. How many directors are required? Section 149 subsection 1 provides that every company shall have a board of directors consisting of individuals as directors. So directors will always be individuals, and maximum is 15. Maximum number of directors is provided as 15. Minimum depends on type of company. For a public company it is 3, for a private company it is 2, and for a one person company it is 1. This is the minimum. In a one person company we have only one member, but directors can be higher than one, but minimum one director is sufficient. And in private company 2 members, in public company uh, in private company 2 directors and 2 members, in public company 7 members and 3 directors are minimum required. And maximum by way of number of members, for a private company it is 200 for a private company. Otherwise maximum in directors it is 15. So next is, a company may appoint more than 15 directors after passing special resolution. So can this 15 number be breached? Yes, it can be breached by passing special resolution. I don't, with word breach I mean, can it be exceeded? It can be exceeded by passing a special resolution. Limit of maximum of 15 directors and their increase in limit by special resolution. So shall not apply to government and section act companies. So this maximum 15 and their increase, this complete limitation of maximum 15 directors shall not apply to government company, which means government company can have as many directors, and section 8 companies, that is company for charitable or special purposes, those companies will not have the limit of 15 directors. Provisions related to women director. Provisions of section 149(1) read with rule 3 of the company's appointment and qualification of directors rules 2014. So rule 3 of the company's appointment and qualification of directors rules 2024 read with section 149(1), provision relating to woman director. So when is a woman director required on the board of a company? Number of women director, at least one. Companies which require to have women director, every listed company, mandatory for every listed company. And otherwise, in case of private company, it should be a private company where paid up capital is rupees 100 crores or more, or turnover is rupees 300 crores or more. So if, and for private company women director is not required. For listed company for sure women director is required, at least one. And for public companies where paid up capital is 100 crores or more, or turnover is 300 crores or more, then at least one woman director is required. Filling of intermittent vacancy, immediate next board meeting or 3 months from the date of vacancy, whichever is later. So in case of intermittent vacancy, if she retires or if by whatever way, if she ceases to be a director, then either in immediately next board meeting a woman director is to be appointed, or within 3 months from the date of vacancy a woman director is to be appointed, and it is written whichever is later. So suppose if within 3 months a board meeting is held, then we still have time to complete 3 months either in the same board meeting. And suppose in 3 months there is no board meeting, then we have to have a quarterly board meeting. So soon we will have a board meeting, and in that board meeting a woman director is to be appointed, whichever is later. On which date the amount of paid up capital or turnover shall be taken into consideration. So as on the last date of the latest audited financial statement, we have to be careful. At times the word is from the latest financial statement, at times the word is from the last dated audited financial statement. So we need to be careful in actual life situation. Provision related to resident director. Section 149, subsection 3. Meaning of resident director. A resident director is who has stayed in India for a total period of not less than 182 days. So he has stayed in India, who has stayed in India for a total period of not less than 182 days during financial year. So here we will check present financial year. If he has stayed in India for 182 days, then he will be considered as resident director. Number at least one. Every company should have at least one resident director. Companies which should appoint resident director, every company should have one resident director. Resident director means who has stayed in India for 182 days in a financial year. 182 days at least. In case of a newly incorporated company, this subsection shall apply proportionately at the end of the financial year in which it is incorporated. So we will check that if it is incorporated in September, so this 182 days will be divided by 2. So half, if the company, since incorporation, if the company has uh, covered duration of half financial year, then we will proportionately reduce these 182 days for the purpose of identifying a resident director. Provisions related to independent directors, section 149, read with relevant rules. So this relates to independent directors. Companies required to appoint independent director. Which companies required to appoint independent directors? Independent directors. First is every listed company for sure. At least 1/3 of total number of directors to be independent director. So for every listed company, at least 1/3 of the total number of directors should be independent directors. At least 2 directors should be independent directors. So 1/3 and still at least 2. At least 1/3 and at least 2, both conditions must be fulfilled. Prescribed class of companies should have independent directors. In prescribed class, we have public companies with paid up capital greater than or equal to 10 crore. So if paid up capital is 10 crore or more, then independent director is required. Again, at least 2 independent directors are required for such a public company where paid up capital is equal to or greater than rupees 10 crores. Public companies turnover greater than or equal to 100 crores. If turnover is greater than or equal to 100 crore, then independent director is required. And how many independent directors are required? 2. Public company aggregate outstanding loan, debentures or deposits exceeding 50 crores. This is exceeding only. If loans exceed 50 crores, then 2 independent directors are required. If public deposits exceed 50 crores, then independent directors are required. If outstanding debentures exceed 50 crores, then 2 independent directors are required. Any fraction contained in such 1/3 shall be rounded off as 1. So if say there are total number of board members, say 7, so 7 board and we require 1/3, so this will come to 2 point something, so we will count as 3. So every fraction contained in such 1/3 shall be rounded off as 1. We will not take nearest to 2 or 3. So this covers our appointment and qualifications of board, and in this we proceed with higher number of independent directors. So higher number of independent directors. Higher number of independent directors due to composition of audit committee in the prescribed companies. Higher number of independent directors shall be appointed. So depending on composition of audit committee in the prescribed companies, higher number of independent directors shall be appointed. Non-applicability. If company ceases to fulfill any of the three conditions for subsequent 3 years, so if in a year company was required to appoint independent directors, and then if subsequent year company is not required to incorporate to appoint an independent director, then still this requirement will continue for at least 3 consecutive years. So once it becomes applicable, then if for 3 consecutive years requirement of independent director is not applicable, then they are not required. Exemption from appointment of independent directors in the following class of unlisted public companies: a joint venture, wholly owned subsidiary, dormant company. So in which classes of unlisted public companies? This is again unlisted public companies. Independent director is not required. If it is a JV, then it is not required because the paid up capital has increased due to pooling of resources, turnover has increased due to pooling of resources, loans, debts are there depending on the background of their JV companies. So in a case of JV, then independent director is not required. Wholly owned subsidiary, for wholly owned subsidiary independent director is not required. And dormant company, for dormant company which is registered with ROC as dormant company, means the activities are not going on, they may happen in near future. So in that case also independent directors is not required to be appointed. Who is independent director? So independent director means a director who, other than whole-time director, managing director, nominee director. Okay, then director other than managing director, whole-time director, nominee director, who is a person of integrity and possesses relevant expertise and experience. So he's a person of integrity, he has relevant expertise, he has relevant experience. Is or was not a promoter, he should not be a promoter, neither is nor was, of the company itself, or he is neither is promoter nor promoter of the holding company or the subsidiary company or the associate company. So of all these, he should not be a promoter. Next is not related to promoter. He should not be a relative of promoters or directors. Okay, to qualify as independent director, he should not be related to promoters or directors in the company, in the holding company, in the subsidiary company, in the associate company. Then next, to be an independent director, he has or had no pecuniary relationship. There should be no pecuniary relationship other than remuneration as such director having transaction not exceeding 10% of his total income. Such amount as may be prescribed with the company, its holding company, its subsidiary company, its associate company, or their promoters or directors. So he should not have transactions with directors, promoters, holding, associates, subsidiaries, main company. He is only drawing remuneration, and apart from that, if he is paid any conveyance or other charges, anything, then that should not exceed 10% of his total income from such companies, holding, subsidiary, associate, promoters, directors. Then he should not have pecuniary relationship during immediately 2 preceding financial years during the current financial year. So we will go back only to the previous 2 immediately previous financial years for the pecuniary relationship. None of those relatives, none of whose relatives holding, and for an independent director, we will check independent directors relative. So independent directors relative, none of whose relatives holding any security of or interest in the company, its holding subsidiary or associate. So we will check independent directors relatives. What are they holding? Are they holding any shares or interest in the company? Are they holding any securities or interest in the holding company? Are they holding any securities or interest in the subsidiary company? Are they holding any securities or interest in the associate company? We will check the relatives. Then, if they are holding, then during the immediately preceding 2 financial years or during current financial year, we will check only this much. Then relative may hold securities or interest of face value not exceeding 50 lakh rupees. So face value should not exceed 50 lakh rupees. The relative may hold securities or interest of face value not exceeding 50 lakh rupees. Okay. So face value is what important. Market value may vary. Face value, if they are holding, then still whether it is within 50 lakhs or exceeding 50 lakhs, that should not exceed 50 lakhs. Up to 50 lakhs is okay, or 2% of the paid up capital of the company, its holding company, subsidiary or associate company, or such higher sum as may be prescribed. So ideally it is 2%, 50 lakhs or 2%. So it is, if the security is held by a relative, then it is up to 50 lakhs, okay, face value, or 2% of paid up capital of the company, it's okay. 2% of paid up capital of holding company is okay. 2% of, up to 2% of subsidiary, up to 2% paid up capital of associate. This is allowed for a relative. So we will check independent director on these points. We will check list of relatives of independent directors on these points. Next is, independent director is indebted to the company, its holding company, subsidiary or associate company, or their promoters or directors in excess of such amount as may be prescribed during the 2 immediately preceding financial years or during the current year. So if he is indebted, then also we will check whether he has any debt due to company holding subsidiary, associate, promoters, directors or not. Then independent director has given a guarantee, provided any security in connection with the indebtedness of a third person to the company, to the holding company, subsidiary, associate, promoter, director of such holding company. So we will check all this for guarantee or security by an independent director for such amount as may be prescribed during the 2 immediately preceding financial years or during the current financial year. Independent director has any other pecuniary transaction or relationship with the company or its subsidiary, holding or associate amounting to 2% or more of its gross turnover or total income, singly or in combination of the transactions referred to above. So primarily, if I look at it, what all I have to check, okay, basically what all I have to check. I am appointing a new independent director. I am obtaining a declaration. However, I can enter into conversation and just clearly know, because if I will not enter into conversation, I'll give independent director a paper to sign. He will sign and give it to me. He will not read and go through all the points. So as company secretary, as professional, my role is to check that I will get his profile, that person's profile. Then I will check his relationship with promoters, whether he is related to promoters of the company or any group entity. I will ask him at the level of group level entity, he is any related to anybody, promoters or directors or any entity, whether his relatives are related in any way, whether his relatives are holding any securities or have any interest in the group companies, whether he has any financial pecuniary relationship existing with the company, and after relative pecuniary relation, then whether he has given any loan or any indebtedness to the company or group companies, whether he has given any guarantee or security in the context of company or group companies, whether there is any pecuniary transaction. So all these points, overall around all these points, I should inquire and come to conclusion that this is not the case. Okay. So next is who neither himself, independent director who neither himself nor any of his relatives. Okay. So independent director who neither himself nor any of his relatives do what? Hold or has held any position as KMP in the company. Then he is not an KMP, he was not an KMP. He is or has been employee of company, holding company, subsidiary, associate. So he or his relative were not employees or are not employees, are not KMP, were not employees. He himself or his relatives also are covered. Then in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. So how much time we will check for himself and his relatives, not KMP, not employee in company and in group companies, for immediately preceding 3 financial years in which he is proposed to be appointed, provided that in case of a relative who is an employee, the restriction under this clause shall not apply for his employment during the preceding 3 financial years. So in case of a relative, if his independent director's relative is an employee, the restriction under this clause shall not apply for his employment during preceding 3 financial years. Okay. Next is independent director is or has been an employee or proprietor or a partner in any of the 3 financial years immediately preceding the financial year in which he is proposed to be appointed. So he is neither an employee himself, he is not a proprietor or partner in any of the 3 financial years immediately preceding financial year proposed to be appointed a director in what? In a firm of auditors. So company's auditors, he is not an employee or proprietor or partner. Company secretary in practice, if there is any company secretary in practice associated with the company, he is not there. Cost auditor of the company, he is not there, or of the group companies holding subsidiary associates. He is not part of their audit firm, secretarial firm, cost audit firm. Any legal or consultation firm that has or had been a transaction with the company, its holding subsidiary associates, amounting to 10% or more of the gross turnover. So, any legal firm, small legal matters are okay. Okay, if legal firm is paid amount more than 10% or more of the gross turnover, then that is not allowed. So we are checking at the level of whether he is related to company and group companies, auditor, secretarial auditor, not secretarial auditor, company secretary in practice, cost auditor, or legal firms, law firms. These all we are also checking. Hold together with his relatives 2% or more of the total voting power in the company. He plus his relatives combined holding is 2% or more, then also he is covered. We will not check individual, we will check as together. Then independent director is a chief executive officer or director of any non-profit organization that receives 25% or more of its receipts from the company, any of its promoters, directors, or its holding subsidiary associates, or that holds 2% or more of the total voting power of the company. So he is a director or chief executive officer any non-profit organization. Then if he is any director or chief executive officer of any non-profit, we will ask simply whether he is associated with any non-profit organization, whether he is director of any non-profit organization, whether he is chief executive officer of any non-profit organization. If he is, then we will dive in about the earnings from the companies, how much that non-profit organization is earning from the company or group companies. Then last is independent director who possesses such other qualifications as may be prescribed. So overall, what we are seeing, we are inquiring about his qualification, experience, integrity. We are inquiring about his association with companies, group companies, promoter, directors. We are inquiring about his relatives, association, equity holding, other interests in the companies. We are talking about whether he's associated with any or cost audit firm, cost auditor, or company secretary in practice, statutory auditor, or a legal firm, legal team, legal consultant if he's associated with them. So overall wider perspective we are seeing, and then he has known pecuniary transaction with the company or group companies. So all these things we have to check, and then we will go beyond that whether he is director or chief executive of any non-profit organization. Then we will check the receipts of that non-profit organization exceeding 25% or not from company or group companies. Next is submission of declaration by the independent director. Section 149, subsection 7. Submission of declaration by the independent director. Section 149, subsection 7. Declaration. Now, declaration for first board meeting. In the first board meeting, when the independent director is appointed, that is his first board meeting, he will declare. Every independent director is required to file a declaration at the first board meeting of the board that he meets the criteria of independence as provided in section 149 subsection 6. Means he complies with all these requirements, he will give a written declaration. And so it is highly recommended that instead of giving him a paper to sign, each point should be discussed and explained, so that if in case by unawareness he is falling in these criteria, then those be covered. Declaration for the first meeting of the board in every financial year, and he has to give this declaration annually at the first meeting of the board in every financial year. Every independent director is required to file declaration at the subsequent meeting in every financial year whenever there is any change in the circumstances which may affect his status as an independent director. So one is, again, this has to be seen as one is every year declaration, plus if there is any change then also a declaration. So one is, there is, he has to file a declaration, and then if there is any change then he has to give a declaration again. It may be interpreted as if there is a change only then a declaration be given. Safer side, annual declarations be obtained, and if there is any change then that be highlighted. Compliance of Schedule 6, Section 149. Schedule 6 is every company and independent director shall abide by the provisions specified in Schedule. This is not 6, this is 4th. Compliance with Schedule 4th. So, Schedule 4th, Section 149(8). Schedule 4th contains certain code of conduct for the independent director, certain things which independent director has to ensure while performing his duties as an independent director. So, company and independent director both shall abide by the provisions specified in Schedule 4th. Why both? Because there are certain requirements on the part of company also, that company will make independent director aware about the processes, give a tour of the factories and other things in the company. So that should also be complied at the time of appointing an independent director and thereafter. Whether independent director can have stock option. Section 149 subsection 9. So we will proceed this further in our next video. Thank you so much for attending this revision class. Disclaimer that this is only for the purpose of revision. Thank you.